Next matter to come before the court this morning is Smrtka versus Boote et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, let me know when you get started. I'm keeping the clock. I can give you a price for the passage of time. We have read the briefs and we're ready to see you on.
May it please the court, my name is Jim Gutbrode. I represent the plaintiff in this case, Philip Smrtka. And the main point that I tried to make in my briefing is that the case was decided in the trial court without the court following correct summary judgment procedure. As this court knows, with a summary judgment motion, there is no genuine issue as to any material fact, and that he is entitled to judgment as a matter of law if he can prove that. But the reality is that in this case, so the court needs to view the facts in a light most favorable to the non-moving party, resolve all doubt in favor of the non-moving party, and reasonable minds can come to but one conclusion. So in our case, we established in detail in our briefing that Dr. Dominic did not follow any of the requirements of Ohio law that govern a chiropractor treating a dog. For example, in looking in the practice of veterinary medicine in RC 474101, and on nearly each of the subsections of that case, of that statute, Dr. Dominic was doing what the law says, which is doing what the law says is a veterinarian's role only. And then 4741.19F is the only place in the revised code wherein a chiropractor could treat a dog, which includes direct veterinary supervision. Neither of those things happen here. So our point is that if Dr. Dominic were following Ohio law, the dog would not have been there, and Mr. Smrtka would not have been bitten. This argument was never really challenged, but instead was ignored by the trial court. Also, the second point is that we made the point consistently. Your Honor, did I ask for 3 minutes?
You just did.
Okay, thank you. Also, we made the point consistently that Dr. Dominic himself testified that for safety's sake, dogs should be separated from human beings, both in time and in space. He said that dogs should receive treatment at a time other than when people are scheduled, but in this case and in others, the dog was scheduled in the same time period. Also, he said the dogs should be treated in separate areas, not used by people, but that was not done either. So again, if Dr. Dominic had simply followed his own rules, the dog would likely not have been there and no injury would have occurred. Just looking at my summary judgment motion, I have Dr. Dominic stating, quote, "So what I do is I have a separate room during off hours away from all patients for safety issues." And he goes on to say, "And so when I get a call from someone to evaluate their dog, I say, since it's not human, I say, we need to do it when all the patients are treated, are done. In other words, a safety so we can keep them totally separate. That's not only it's good ethics, it's my moral obligation. If I want to help someone out, they do it outside of when we treat our patients, our humans. So in my mind, safety would include that the priority is that we work with human care. And if I'm going to evaluate a dog, it's got to be during separate hours. So the safety would be a separate time zone." That's what Dr. Dominic testified to, and yet all the evidence is that that never happened here. The dog was sitting in the lobby people in and out. His owner was there, Mr. Smrtka was there. There was no separation between the dog and the people. Not only in terms of spatially, not only in terms of temporally, but spatially as well, because he himself says that the dog should be treated in separate situations, separate conditions. And we had testimony about me coming in through a different door, not using the same examination room as the chiropractors' patients do. There was solid evidence established on these points. Therefore, there was at least in fact, an undisputed question of fact as to whether Dr. D was negligent, Dr. Dominic was negligent, and failed to use ordinary care, and a question of fact as to whether Dr. Dominic's negligence caused Phil Smrtka's injury. I made the point in my brief, and I'd like to reiterate it again. The trial court made two statements in its order that lie at the heart of the court's reasoning and also at the heart of the trial court's error. On page 7 of the trial court's order, the court writes, "When the evidence is viewed in a light most favorable to plaintiff, the injury to plaintiff would still have occurred whether or not defendant was in compliance with the Allied medical support statutes. The evidence reveals that the proximate cause of plaintiff's injury was not defendant's non-compliance with the Allied support medical statutes, rather it was plaintiff's attempt to pet Luke." And then on the 9th page of the trial court's order, "Although it is true that if Luke were not there, plaintiff would not have been bitten. However, the proximate cause of plaintiff's injury was placing his hand in front of Luke's nose, which prompted Luke to bite him." And the court never addresses how Mr. Smrtka could place his hand in front of Luke's nose if Luke were not there.
Mr. Boote, can I pose a hypothetical to you, and perhaps maybe you can distinguish between my hypothetical and this case? If I were to be, hypothetically, driving a vehicle while suspended, and someone rear-ended me, it sounds as though your argument is, on behalf of the second car, had I not been there on the road with my suspended license, never could have rear-ended me. Yet, in law, my suspended license would have nothing to do with negligence. So can you differentiate your case here for me?
Yeah, thanks, Your Honor. I have cited several cases in my brief to the effect that a failure to follow your own rules is indication of negligence. And that's the point. I'm not suggesting that we should do a disciplinary action against Dr. Dominic. I don't care about that. What I did try to show was that there is a genuine issue of fact as to whether or not Dr. Dominic was negligent, and whether that negligence proximately caused Phil Smrtka's injury. And the fact that he didn't follow the veterinarian statutes, the fact that he didn't follow the Allied medical support statutes, are all indications not of a disciplinary problem, but of a fact that he was not negligent, or he was negligent. And that negligence, I believe, caused Phil Smrtka's injury. But the reality is that the basic problem we have in the case is that the trial court failed to follow the appropriate, correct summary judgment procedures. The court below failed to resolve all doubts in favor of the non-moving party, resolve all doubts in favor of the non-moving party, and construe all the evidence and all the inferences toward the non-moving party.
Sir, can I ask just another real quick hypothetical?
Sure.
What if this happened in the parking lot outside of Dr. Demonic's office? Then what?
Well, you know, I think the point is that we all agree that he was a business invitee. My client was a business invitee. I guess the question would become if he's out in the parking lot, is he still a business invitee?
It's on the premises, building premises, it's not always gonna be able to get into the business, right? So if this woman has her dog in the parking lot, on her way in or way out, and there's a dog, and
person is there to be treated by the chiropractor, and the dog is there to be treated by the chiropractor, then I think it's the same case. But it's even more egregious here because she was bringing the dog into the place for treatment. And, as a business invitee, there is a duty to maintain the premises in a reasonably safe condition so that its customers are not unnecessarily and unreasonably exposed to danger. And that's the duty, and that duty was not followed here. So, and I will respond when my turn comes up again.
Good morning, Your Honors. Mike Rudinger. I'm here to represent Dr. Gary Dominic in his chiropractic practice. The other gentleman at the table is Mr. Mark Cura, who's here with the Cincinnati Insurance Company. And I would like to address briefly why this court should affirm the lower court's summary judgment decision, turning to three main aspects of the record, which, in my opinion and in the trial court's opinion, were dispositive of each of the claims that plaintiff actually raised. The first one of those would be relevant to the premises liability claim, and the key facts are that plaintiff himself testified he saw Luke was there, and as an experienced dog owner, he knew not all dogs have friendly temperaments, and that you should never approach a dog and attempt to pet them when they're unknown and you haven't previously asked the owner, but nevertheless chose to reach his hand under Luke's snout without warning and attempt to pet him. Second, as to the chiropractic negligence claim that plaintiff rose, related to the care and treatment Dr. Dominic provided him, he testified specifically that he was satisfied with the chiropractic treatment, and the record shows he in fact continued to treat with Dr. Dominic following the dog bite. And third, as to the allied medical support issues that plaintiff's counsel has raised, there was never a claim raised under the allied medical support statute in the complaint. It does not provide a private right of action, and to the extent that counsel is attempting to make this a negligence per se claim, borrowing a standard of care from the allied medical support statute, it's not an appropriate statute under which to do that, and the proximate cause issues, consistent with Ohio's superseding cause law, show that plaintiff was in fact the proximate cause of his own injury. Now, I turn first to the premises liability claim, which plaintiff himself described as his main claim. And the issue here, no one disputes the fact that plaintiff was a business invitee. So the question becomes, what was the duty of care owed by Dr. Dominic to plaintiff? Consistent with Ohio's open and obvious law, when a business owner has an equal awareness of any risk, and plaintiff himself has an opportunity to appreciate a risk and take measures to protect himself, the business owner can anticipate that plaintiff will do so and protect himself. Here the record shows that plaintiff appreciated that risk and failed to take any action to protect himself. He testified specifically. He saw Luke in the waiting room, he realized he was there, and even though he's an experienced dog owner, he admitted he knows not all dogs are friendly or like to be petted. You can find that on page 25 and 26 of plaintiff's deposition. It's at the record at 63. He also agreed that it's always prudent to ask permission before approaching an unfamiliar dog. And in fact, he agreed that had he not reached his hand towards Luke, he probably wouldn't have been bitten in that circumstance. Under this case, and I would direct this court's attention to, there's a common pleas court case cited in the briefs called Crowley. And it provides a very illustrative example of the analysis that applies here. There was a truck driver who came to a business lot in order to pick up a delivery of sand, I believe it was. Had no idea that there was a dog present, and when she arrived at the scene, saw the dog and was bitten after attempting to pet it. The court looked at whether or not the question of whether the dog was there, which has been plaintiff's main contention, but whether or not the truck driver in that case would have been able to anticipate any kind of injury and take measures to protect themselves. She didn't. And also whether the person who owned the lot and knew the dog was there was aware of any history of aggression or anything like that that would pose a greater risk. Now, in our case, and as in the Crowley case, here the record is undisputed that Dr. Dominic was not aware that Luke the dog had any history of aggression or any previous bite history. And as such, there was nothing he could have known that was different than what Mr. Smrtka knew when he came in the waiting room.
Is there also testimony in the doctor's deposition that he was aware of potential safety issues when the dog was there, when there were other patients coming in?
In terms of general practice, Your Honor, yes, but those were general statements about dog safety and saying, yes, it's good practice to keep dogs away from or separate from patients and to treat them separately. But in this case, the superior knowledge case law under Ohio Law Council requires knowledge of the specific condition that caused the injury, so a specific risk unique to that circumstance. That's why I'm focused on, and the Crowley Court properly focused, on whether the business owner had any knowledge of a particular dog bite history specific to that dog. So,
Does the testimony, or does the record reflect that the plaintiff asked the dog's owner at the time whether or not he could pet the dog, and was there an interchange regarding the dog?
it's clear, Your Honor, that Mr. Smrtka did not ask. It's undisputed in the record that he chose of his own volition without warning to reach over and attempt to pet the dog. I think the record shows that the only words that were used were plaintiff himself saying, "Oh, what a pretty dog," as he reached under the dog's mouth. So in this case, Mr. Smrtka and Dr. Dominic had every bit the same awareness of any risk that Luke would pose. And in this case, Mr. Smrtka himself testified, "Yeah, I'm an experienced dog owner. I know you shouldn't attempt to pet a dog without warning." And yet he threw caution to the wind and did exactly what he said he knew he shouldn't have done. In that case, the risk was open and obvious and consistent with Ohio law. Plaintiff failed to take any action to protect himself. And under those circumstances, the risk is considered open, obvious, and plaintiff cannot recover under premises liability.
Is there case law regarding whether or not a dog's propensity to bite has been determined to be open and obvious? Like we have the horse case law, right?
Right, right.
Always a problem, dogs.
Specific to propensity to bite, no. The only thing I can show Your Honor in terms of a court analyzing specifically whether it matters that history of bite, or bite history would matter, would be the Crowley case where it said as long as the business owner has no knowledge of that, then it can't be considered an open and obvious condition. I'd encourage your court to read it. While it's not binding precedent coming from the common police court, it is very illustrative and I think on point here. Now, I would like to speak briefly to the chiropractic negligence claim that plaintiff raised, and specifically point you to paragraph 15 in the complaint, in which he alleged that Dr. Dominic deviated from the standard of care and was negligent in the care and treatment he provided to plaintiff. And I think the record disposes of this quite neatly, because when asked, Dr. Dominic agreed that he was happy with the care and treatment that Dr. Dominic, as a chiropractor, provided to him. That's at page 61 of his deposition testimony, 63 in the record. And that fact alone should be dispositive here, in terms of the fact that the negligence claim, chiropractic malpractice claims, it's count 3 in the complaint, relates to the care and chiropractic treatment Dr. Dominic himself provided. Luke's presence, if we're going to address it, should be addressed under the 4th count, which is the count for scope of licensure in the complaint. And that's where plaintiff has discussed the Allied Medical Support statutes. Now, what's important about the Allied Medical Support statute is that, apart from never being actually alleged in the complaint, is that there's nothing in the record and nothing in Ohio law that would allow it to be a private right of action for a plaintiff in a case where he's been bit by a dog. Specifically, the Allied Medical Support statutes provide conditions under when, with appropriate veterinarian support, a non-veterinarian may take care of or provide care and treatment to a dog. There's nothing in the statute that specifies whether or not the dog should be present in a waiting room or what time the dog should be seen. It's more tied to the supervision aspects of it. But what's particularly important about it is that the Allied Medical Support statute, to the extent we're trying to talk about a negligence per se theory, isn't the kind of statute that would create a right of action for a third person to borrow it as a standard of care. If this court looks to its case in, the 2nd District's case in the Moreland, which is cited on page 16 of our brief, you'll see that the analysis for a negligence per se under Ohio law is whether the legislative enactment in question does not define a civil liability, but instead only makes provision to secure the safety or welfare of the public. If it's that latter, if it's a safety or welfare statute that doesn't create a specific civil liability, it's not appropriate for a negligence per se claim. Under this court's Neunschwander opinion, it shows the focus here is whether the plaintiff who is attempting to take advantage of a statute as a negligence per se standard falls within the class of individuals the statute was designed to protect. Nothing in the Allied Medical Support statutes makes mention or reference to the safety of third parties. It discusses the doctor treating a dog. It discusses the veterinarian, and it discusses the dog. Mr. Smrtka is none of those three, and therefore cannot assert a negligence per se claim under the Allied Medical Support Statute. But even if he could, there's a proximate cause issue that not only dooms that case, that count, but all three of the counts. And that's the fact that, consistent with Ohio law, we look at whether or not what the actual, immediate cause of this was. So let's talk about a world that Plaintiff's counsel suggested in which Dr. Dominic was in compliance with the Allied Medical Support Statutes. There's nothing on the record here to confirm that Luke the dog wouldn't have been present if he complied. Because the statute is clear, if the proper supervision is there, Luke could have been there. In that world, there's nothing in the record to show that the bite would have been any different. Because if you take away any particular fact from this case, the only one that makes a causal difference is the penultimate fact that Mr. Smrtka decided, without warning, without asking, to stick his hand under Luke's nose and precipitated the bite. The trial court found that was the dispositive proximate cause fact. And by the way, that's also consistent with Ohio's treatment of superseding and intervening cause, where it says even if there may have been another but-for cause, it's that final action. In this case, an action that was taken, even though Mr. Smrtka said, I know better, that precipitated the bite. And so that fact is what the trial court found was the cause of the bite here. It was, in the context of a premises liability claim, an action taken fully aware of the potential risk and yet not taking any action to protect himself. In the chiropractic negligence case, it was an action taken outside of and with no relevance to the actual chiropractic treatment or care given to Mr. Smrtka. And in terms of the scope of licensure claim, it was an action that obviated whether or not Dr. Dominic was in compliance with Ohio's Allied Medical Support Statutes in the first place, because it was Mr. Smrtka's action and not non-compliance with the Allied Medical Support Statutes that actually caused the bite.
Counsel, in terms of the proximate cause issue and what's been discussed, and it caught my attention in the court's decision, couldn't the argument be made that that's actually more to comparative negligence?
Your Honor, I know plaintiff's counsel referred to this in their briefs.
Caught my attention before I read his replies.
Sure. So the comparative, in this case, no, respectfully, Your Honor, it wouldn't go to comparative negligence because this is an action that was the immediate precipitant and severed any other causal chain by affirmatively taking steps that would have caused this. If you take, you can assume compliance with the Allied Medical Support Statute, or you can assume non-compliance with it. But in either world, the actual cause of this injury was the decision to reach out, stick his nose under Luke's snout, and precipitate the dog bite by doing that. So it cuts the severs a chain of causation completely, which is why it wouldn't be a comparative negligence issue.
Because solely of the assumption of the risk? Because you're indicating that on summary judgment, the trial court could find there was no probable cause because the plaintiff assumed the risk that the dog might bite.
We wouldn't say assumption, there's some overlap there. We wouldn't say assumption of the risk is an actual affirmative defense in this case. It's more a proximate cause issue as a matter of law, whereas assumption of the risk, there could probably be a question of fact if it was being raised as a defense. It's also relevant specifically to the premises liability claim, which again, plaintiff called the main claim here, in that there, as a matter of law, it's that failure to take action to protect oneself that cuts off the claim as a matter of law, as one of the elements of a premises liability claim, as opposed to a defense that would be raised there. So again, with respect to premises liability, if we look at the basic elements in the complaint, it's missing the actual, if the duty is a duty to an invitee, Ohio's open and obvious law says there's no liability if the plaintiff was equally aware of the risk and failed to protect himself. And it's that failure to protect himself that requires dismissal of the open and obvious claim. And on the Allied Medical Support claim, we have to think about what goes into a negligence claim. So even if you borrow the Allied Medical Support statute to show duty, you have to show breach. And not only does the plaintiff not able to show breach because of proximate cause, it's actually illustrative that in their cross motion for summary judgment, they moved only on the issue of negligence and not on the issue of breach, which is why the trial court was correct to deny the cross motion for summary judgment, because you can't grant summary judgment with respect to one element as opposed to an entire claim under Ohio law. So with that, Your Honors, I thank you. I would encourage you to affirm the decision of the lower court. Thank you.
Counsel, you have about 4.5 minutes remaining.
Okay, thank you. In the 19 pages of their brief, and here, the defense never addresses that if Dr. Dominic had followed the law, the dog would not be there. The duty of care is to open and obvious. Again, the dog would not have been open and not obvious if the dog wasn't there. And the dog should not have been there if you follow the law of the state of Ohio. The dog shouldn't have been there. And, as far as proximate cause, I tried to cite in my brief that there's plenty of law that says that that's not an issue for summary judgment. Summary judgment the question is whether there's a genuine trial or a genuine issue of fact for trial. And that wasn't addressed at all here. I mean, are we going to say that we're going to put all the blame on Phil Smrtka because he reached down and pet the dog, as opposed to, and then just ignore what Dr. Dominic did, which was to totally not comply with Ohio law and acted as if he were a veterinarian because he's following exactly what the veterinarian statute says a veterinarian is allowed to do, not a chiropractor. So they would have us put all the blame on Philip Smrtka and no blame on Dr. Dominic, even though Dr. Dominic himself says that there should have been separation. There should have been separation, spatially and temporally, from people. That he himself says that, and I read for that. So the point I'm trying to make is, and that goes to your point, Judge, that the duty to obey Ohio law has to do with Dr. Dominic's negligence. If Dr. Dominic followed Ohio law, then this would not have occurred because the dog would not have been there. And this court, I cited at least 10 cases in my brief. This court keeps sending cases back because the summary judgment procedure was not followed. And that's what we have here. The arguments that I've tried to set forth and the inferences that we draw from those arguments are supposed to be all construed in favor of the non-moving party. But that was not done here. And I urge this court to reverse the decision and to let the case go back to trial, because that's the place it's supposed to be. There's a genuine issue of material fact, and Dr. Dominic is not entitled to judgment as a matter of law. Thank you.
Thank you both for your presentations today. The court will take the matter into advisement and will issue a written decision which will be mailed to all sides as well